I'd like to welcome you back to the show. It's our pleasure to welcome Jeffrey Clayton. He's a lawyer. He's the executive director and policy director of the American Bail Coalition. He's worked in various capacities in that as a public policy and government relations professional for 15 years. And this is a serious issue, folks. It's a little tricky to understand how the bail system works. But the bottom line is compared to the fix that some people want to impose or inflict on us, we're in serious trouble here. Jeffrey, welcome back to the show.
Pleasure to be on. Thanks for having me.
So explain how the bail, fortunately, many of us have no experience with bail, knock on wood. Could you explain how the bail system, why it was created, and how it's supposed to work? And then we're going to talk about how some people want to, quote-unquote, fix it. And then this latest news of these university researchers and other analysts saying that their fix is raising grave concerns.
Absolutely. So the current bail system dates to medieval times. The way it works in California right now is that all jurisdictions are required to have a bail schedule, which are preset based on the crimes alleged to have been committed so that people can bail out immediately in California. And then if you can't afford your bail or if the judge wants to impose additional conditions, you can go before a judicial officer and ask for a reduction. And that's when things like ankle monitors and, house arrest and all that kind of thing can become different options for people to get out of jail. And so the fix that's being proposed, obviously, was Senate Bill 10, as we've discussed on previous shows, which essentially would instead say that we will use an algorithm to sort people into three categories. And if you're in Category 1, you go home. Category 2, we tram all your other liberties. In Category 3, you stay in jail. And we're going to use this computer to decide it. And I think that's the controversial move that you're talking about.
Well, could we back up just a little bit in terms of helping people understand why sure. Was bail created? Why is it in the Constitution or how is it embodied in our law?
Yeah, it dates to the Magna Carta. Why bail was created is to create an exception for people to get out of jail when, at that point, they were locked up by the Crown. And so as the 1600s happened, I mean, really what was happening is that if you were a political opponent of the state, we would just lock you up and throw away the key, which is why bail was created, so that you could get out and you could present your own defense and that sort of thing. So bail is in the Constitution. It's in the federal Constitution, 8th Amendment, prohibition against excessive bail, which presumes there's a right to bail. And then, of course, in the California Constitution, which says that all persons shall be bailable by sufficient sureties, meaning by a judge setting a bond that they believe to be sufficient that offers the person, the opportunity to get out. So it's ingrained in our criminal law, for 500 to 700 years.
Okay, and so my first question, based on that history, is: are these movements against eliminating the bail system, even though they say they're tweaking it, is it constitutional?
Well, I don't think Senate Bill 10 is constitutional because it purports to eliminate a right to bail as we've known it in California since statehood. And I think it takes a change to the Constitution to do that. And so, New Jersey went down this road, and you can implement a system like that, but you have to change your state constitution to implement this new kind of no money bail system, and it's not as easy as just passing a simple bill.
So, and this is the other thing I'm trying to figure out. So, I'm reading this literature that from the professors and the researchers and the analysts, and part of it is addressed to Hertzberg on his bill. But wasn't this already signed into law? Yeah,
but I would point out that 100 civil rights groups came out against these, a week or two before the bill became law, and that didn't stop them. 80 digital groups, including Google, Facebook, and other big companies, IBM, Samsung, et cetera, have come out against these. And now this final piece of 27 academics. But nothing seems to stop them in Sacramento. And whatever they seem to want to do is what they do, and it doesn't really matter when you have 27 prominent academics saying this is a bad idea.
So when you say a bail schedule, does that mean, okay, this person's charged with robbery, to get out of bail, that's, $10,000 bail? Or if they did aggravated assault, there's a price with that, and then the judge has some fudge factor there?
Yeah, and they're temporary, right? So let's say you get arrested on a Friday night, you're going to have court on Monday. If you get out, if you don't get out. If you do get out, then at that point the prosecutor could ask for an increase. If you don't get out, you could ask for a decrease. You could ask for a recognizance bond. You could ask for a reduction in bail. So a bail schedule just kind of functions temporarily before we can get people in front of judges.
So, and then some of the reasons that go into a judge either issuing bail or jacking the price up is, for instance, like flight risk, whether or not the person might do more crime, like go after more victims, and what are some of the other factors they look at?
Yeah, so those are all laid out in the court rules and the statute. It could be things like ties to the community, your employment status, how long you've lived in the community, whether you have relatives in the community, kind of your stability as a person, whether, like you said, whether you've fled the law before, whether you've appeared in court as required before, your prior criminal record, and of course, is there some risk you're going to do this to another person in the community, and that's definitely, what judges are looking at when they arrive at the final number.
Okay, so let's go over SB 10 again. You said it uses an algorithm to come up with three scenarios or possibilities?
Right. So Senate Bill 10 relies heavily on a pretrial risk assessment algorithm that is going to group people into three categories: high risk, medium risk, and low risk. And, if you're low risk, you're walking. You're not going to have to post bail. You're out of there. If you're medium, you're going to get supervision by a statewide pretrial program that the state of California is going to pay for. And that's going to be monitors and drug screening and all that sort of thing. And then if you're high risk, you're going to get detained. There will be no bail for you to post. You're just going to get locked up, and we're going to throw away the key. And so we're going to use this group-based historical data to put the people into the categories, which is why the researchers have ultimately said that's a bad idea.
Now, the other thing going on here, I remember from our previous discussion, is doesn't a judge still have the ability to say, well, I don't buy any of this, you're going to get detained, and in actuality, that this is one of the reasons some of the civil liberty groups didn't like this, is because they think it could actually decrease the number of people that are out on quote-unquote bail because they're going to end up just saying, screw it, you're being detained.
Yeah, I think that's the inevitable march to preventative detention is what I like to call it, because what will happen is that we'll start releasing people, and then the judges won't have bail as an option, and so it's either release or detain. And we know over time in the federal system the judges have chosen detention. We've seen in New Jersey the growth of motions for detention. And so, how politicians are. When something bad happens and it's on their head, they're going to come out and go hard against crime again. So I think over time you'll see a bunch of releases to start because the prosecutors won't have money and they won't be able to prove these things. But over time, you'll see judges and prosecutors starting to hammer people and probably be able to get it, presuming that it's constitutional.
All right, we're going to take a quick break. Before we do, where can people pick up the information you and I are discussing right now?
Go to our website, ambailcoalition.org, and we have a resource center and also various news articles about the current state of affairs on the issue.
All right, when we come back, we're going to talk about the analyst basically pointing out the flaws in this program. What's wrong with letting a computer program or a formula make these decisions instead of a live judge? You're listening to The Andy Caldwell Show. We'll be right back. Stay tuned.
The Andy Caldwell Show is sponsored in part by CoLab, the Coalition of Labor, Agriculture, and Business.
Intelligent, informative, and interesting, with something new each and every day. You are listening to The Andy Caldwell Show.
I'd like to welcome you back to the show. My guest, Jeffrey Clayton, Executive Director of the American Bail Coalition. The California legislature is trying to get rid of the bail system, even though it's enshrined in our Constitution and the United States Constitution. There's some social justice types that think this is a better deal, but Jeffrey, if I remember correctly, didn't like the ACLU or NAACP or somebody else like that come out against this system?
Yeah, over 50 civil rights groups opposed the passage of Senate Bill 10, including the ACLU of California, the ACLU of Northern California as well. And so the problem was, the language came out. It's some dispute as to when it came out, but it was a matter of days before the language came out, and then the governor ultimately signs the bill. So the reality was those groups didn't really have time, and neither did we or anybody, because you just got dropped a new bill and told that it's going to become law in 3 days. So it was really, really difficult to stop.
So you guys are still weighing in, even though this got signed into law, because I guess they're working out the details, and a bunch of academics, very highfalutin academics from some of America's premier universities, MIT, Harvard, Princeton, and Berkeley and Columbia, have weighed in saying this system has got flaws. Could you tell us what they came up with and are recommending?
Absolutely. And so their biggest issue, I think, is they don't think it's predictive, which means it doesn't predict within risk categories. So, for example, if high risk is a 50% risk of failure, we have one good guy and one bad guy, but the system's going to tell us they're both bad guys and not be able to distinguish between the two. The other main thing I think that they were concerned about was racial bias in the system. They're not confident that these things can do anything but harm on that issue rather than actually solving it, which is what the people on the other side would have had us say. I would say the conversation is still alive in California because there is a referendum effort that was successful on Senate Bill 10, and the voters will get to vote on whether they want Senate Bill 10 or not in the November 2020 election.
That's why it's in abeyance, right? Because it's in abeyance because it's going to be determined by referendum?
Absolutely.
And so, for instance, some people say the system we have right now is biased, that, for instance, a poor black guy gets busted for something he didn't do, but he doesn't have a job. He can't bail out, and he doesn't want to lose his job, so he pleads guilty to try to get out on something less. In other words, that there's racial bias in the system right now. How is the algorithm supposed to address that, and why did the critics say it won't work?
Well, it was supposed to base the system purely on risk and factors that we thought were race neutral, that we later found out were not race neutral. Things like whether you own a house or not. One algorithm in Texas was considering the use of whether somebody grew up with a father in the home or not. And those don't sound racist on their face, but if you look at the actual percentages of people in those categories, they're largely, minority groups. And so that's what we realized is that not only did it not make it better, did it not ignore these factors, it basically baked racism that exists into the system permanently by using backward-looking data and locking us into the past.
And I know that you guys put forward, when this was all being debated, you guys put some forward what you thought would be meaningful reforms versus just tossing this baby out with the bathwater. What were those?
Yeah, so we had a package of ideas, which we still are pushing forward, which would be to lower the bail schedules, to decrease reliance on the bail schedules, perhaps even to get rid of them and set bail in court 24 hours a day in California, which would mean we wouldn't need all this back-end due process. And we also need back-end due process in California, as the Court of Appeals has said. Judges just rely too heavily on the schedule. They don't adjust them down. They don't adjust them up. They don't do an individualized consideration, which is what is necessary. So I think if we could bring the marketplace of bail into a better balance, work on some of these due process issues, and, we're not against alternatives either for folks that are mentally ill and need treatment. I mean, obviously that's going to be the better pathway for them. And those would be, if the state has resources for things like that, that would be meaningful change that could actually have a real impact.
So are judges allowed to weigh in on this stuff? Did judges send letters saying what they think would or would not work? Are they allowed to do that?
Well, some organizations opposed, at least one judge organization in California, and I forget the name of it, opposed Senate Bill 10. Of course, they're on thin ice by doing that because the Supreme Court Chief Justice supported the legislation along with the governor's office. And so for other judges to come out against that was a difficult proposition, given that the head of the state judicial branch was pushing this.
So, and then I read this thing that in another state, their Supreme Court just handed this thing down by fiat.
Yeah, so we've been battling the Missouri Supreme Court on that issue. Notice in the article it was one of the other, the three letters, one of them was to the Missouri Supreme Court saying, you've screwed this up. You've required an algorithm, and we don't think you should do that, and they did it by court rule, which was unfortunate because there was really no public process or public input in the entire process.
So how do they, I mean, you talk about judges legislating from the bench. How in the heck do they have the authority to do that?
Well, in Missouri, they've got a weird rule where the only requirement to pass a court rule is you put it out 6 months in advance. And that's it. And they don't have to have any rules process or public process. Luckily, in California and other states, there is some due process. And, the Missouri Supreme Court tried to tell us, well, we had a panel, and I said, well, who was on it? Right? Well, there were a lot of people on it. Well, who? And so you just don't know. So it's just an anomaly that they have. And, of course, they tried to correct the rules a week before, which then rendered that portion unconstitutional, which we burned them on, and then go back and put those out in delay. So it's true legislating from the bench, and pretty much shotgun legislating from the bench from what we can tell.
Okay, so let's set up this 2020 referendum. You got 50 civil rights groups don't like this thing. Is there somebody pushing for it? Like who's going to be campaigning against whom?
Well, we're not sure yet. I mean, certainly the Service Employee International Union supported it. We think because of the growth of jobs as pretrial services, sort of probation officers, would be unionized, so that would kind of boost their roles. But I don't know if the public policy, as it turns out, is worth them going to fight over that. And I think if they're going to increase criminal justice professionals, there's better places to put them than pretrial services, and maybe they'll look at expanding probation or mental health services. But at this point, we don't know. We don't know whether everybody's just going to finally agree that this is a bad idea and we ought to go back to the drawing board, which is what we're hoping.
So
we think that'd be the best solution.
Can you, let's say that Hertzberg and some other people see the light, would you pull the referendum? Can you still pull the referendum?
Yes, my understanding is it can be pulled, and that would be the folks on the board of that particular entity would ultimately make that decision. I'm not part of the kind of making that decision, other than to just run the trade association that I represent.
Have you guys sat down with Hertzberg and with other groups and presented this stuff, or is it just all by correspondence?
I have sat down with them. We just don't see eye to eye, unfortunately. I think the issue changed right in the middle of it, and some folks got kind of further down the road than maybe they should have on some of this stuff, and
so their ego got tied up to it.
We're just when you get dug in on a certain issue so hard and you fought so hard for it, and it changes on you, it's really hard to just say, "Well, I was wrong." All right. And so we understand that.
All right,
and certainly we were wrong on some things too, but that's okay.
All right, Jeffrey, thank you for giving us so much of your time today.
You got it. Have a great day.
All right. Jeffrey Clayton, Executive Director, American Bail Coalition. You're listening to the Andy Caldwell Show.